You're tuned in to Agriculture Today, and we start this Wednesday show with some information about agricultural law. And to share some of his knowledge, we have K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
And Roger, something we wanted to talk about today was farmers having issues with the Missouri River flooding and causing damages to their fields.
Yeah, that's right, Shelby. From about 2007 to 2014, there were flooding problems in numerous years along that Missouri River corridor, basically all the way from St. Joseph, Missouri, up to Fargo, North Dakota. And anybody that drove Highway 29 or Interstate 29 during that period of time noted that there were a lot of farm fields that were flooded. The Missouri was out of its banks. There was a lot of damage in that corridor. And we've had litigation over that that's been going on for about a decade, and finally have, I think, a pretty good resolution of this for the farmers involved, and it looks like it'll be a final resolution. Of course, the U.S. Supreme Court would remain, but now we have the U.S. Court of Appeals for the Federal Circuit out of D.C. that has basically agreed with the trial court, Federal Claims Court, on a takings issue, but then expanded it a bit. And so there's going to be even more relief for these producers and landowners in that corridor than what the claims court had said.
And to my understanding, the flooding didn't just happen. The Corps of Engineers kind of created the issue, which is what made this a case.
Yeah, that really is a big part of what the case is, because the Corps had made changes to their master manual, which is what it's called, in 2004. And then some other changes after 2004 in their processes to basically re-engineer the Missouri River and establish what they said were more natural environments to facilitate species recovery of wildlife that uses the Missouri River. And those changes led to unprecedented releases from Gavin's Point Dam in South Dakota after heavy spring rains and snowmelt were already creating a high river level in 2011. Of course, the snowmelt and the heavy rains were out in Montana, and that was already filling the river up. Well, then the Corps added more water to that, and the claim was that that's what exacerbated the problems, made them worse. And had the Corps not done that, the problems, we may not have had the flooding, or definitely would not have had the flooding to the extent we did. And so the primary question was, is the Corps responsible for that? Was there some type of causal tie between what they did and the damage the farmers sustained up and down that Missouri River corridor? And the way you pitch this as a takings claim is that, well, this is a government agency, and the government can take my property if they want to. They're the big bad government. They can do that. But the Constitution says if the government takes your property, the government has to pay what the Constitution calls just compensation for it. And so this was pitched or couched as a takings case in the U.S. Court of Federal Claims, which is where all the takings cases go under the Tucker Act. And the Court of Federal Claims said, yes, there is a taking, but that the farmers could not receive compensation for crop damage and some of the property damage. But the government had taken what's called a flowage easement over their property. That has to be compensated for. The farmers appealed this and said, well, we should be compensated for our property loss and our crop revenue loss too. And the appellate court agreed with that. And so now it's going to go back to the lower court on remand to calculate those damages.
Even though it's affected things in the past, are they going to see compensation possibly for things moving forward as their land is still damaged?
Yeah, we had basically 44 landowners up and down that corridor that was selected as what we call bellwether plaintiffs to establish the Corps' liability. Now, what the court on remand has to determine is the extent of the damages, the property owners that are involved in this that should be compensated, and the value of lost crops and the future value of lost crops, because that land has been damaged for some time. It'll recover eventually, but the productivity of the land is much less now than it was prior to the flooding. Now, eventually that will come back. And so now you're going to have expert analysis, economists, soil agronomists, those types of things. And it's going to be very costly to the Corps, because the Corps is going to have to pay for all of this to determine what the damages are, and then they're going to have to compensate the farmer. So there's still quite a lengthy road to this, but the resolution of the taking issue is done, as far as I can tell. Now it comes down to the calculation of the actual damages and the parties that are entitled to those damages.
A part of the case then is wrapped up, and the farmers did get some compensation. However, it's not done yet.
Yeah, they will get compensation, but we don't know the extent to that level yet. But what we do know is that in the compensation, it will include damages to their property and crops.
And speaking of compensation, a farmer who maybe did not get compensated in a different case, discussing a bridge being fixed that then created his wheat crop to flood.
This was a state case down in Louisiana, the State Court of Appeals in Louisiana. And what you had was a farmer that was growing wheat, and that his field would normally drain into a ditch that flowed alongside a road and went under a bridge down at the road. And that ditch that flowed under the bridge became filled with silt over time and then debris. And this was a state bridge, a state highway and bridge, so the state was responsible for maintaining that. And there were several days of heavy rains. The farmer notified the State Department of Transportation that there was a blockage, and he needed that to be cleared so his field would drain and his crops wouldn't flood. We made a request. He made a couple more requests on consecutive days. The state eventually got there, but 2 weeks after his first request, and after 6 days, his crops were lost. He lost the entire wheat field, and then the state comes and fixes the obstruction. So he sued, saying that was negligence on the part of the state. He should be compensated for his crop loss. And the court said, no, the standard of review here on the state government agency, in accordance with state law in Louisiana, and this is going to be pretty much the outcome everywhere else, was whether the state acted within a reasonable time. And the court determined that based on the circumstances, they did. Their equipment was committed elsewhere, their workers were committed elsewhere, and they got to the project as soon as they could. Unfortunately for the farmer, it was too late.
So how does this court case really compare to the one we've just talked about?
Well, the one we just talked about was a takings case, and that invoked the constitutional requirement to pay compensation. This state case was couched as a negligence case, that the state basically acted negligently, causing him damages. And so when you have a negligence case, there are four elements to recovery. You have to have a duty to act, a breach of that duty, the breach causes damages. And obviously he had damages. He had to establish that there was a duty that the state had to clear that obstruction. They breached the duty, which then caused his damages. And the court said that they didn't breach their duty. They acted in a reasonable manner. So two different types of cases, two different legal analysis. One was a constitutional takings case. One was a negligence-based case.
So for this wheat farmer, hopefully his crop insurance is doing something for him?
Yeah, hopefully he gets a recovery through crop insurance that can make him whole. Otherwise, it's a really bad result for him.
One more case that we wanted to talk about today was the importance of a buy-sell agreement, especially for estate planning.
Buy-sell agreements, I think, are probably almost as important as a properly drafted will or a trust is for many farmers and ranchers, particularly those that want to keep the farming or ranching operation in the family from one generation to the next. It's a good intergenerational transitional device to use. Now, with that much said, of course, the agreement has to be operational, and the way that we make that operational often is by the use of life insurance. What we have here is a recent case coming out of Missouri. It's a decision on appeal by the U.S. Court of Appeals for the Eighth Circuit. And the issue in the case was when the family corporation that in this instance was owned by two brothers, owns the life insurance policy and the proceeds are paid to the corporation to be used to redeem a deceased shareholder's stock. The question is whether the value of that life insurance, the proceeds, add to the stock value of the corporation, add to the base value of the corporation for purposes of estate tax. And the two prior cases on this that we've had from the Ninth Circuit and from the 11th Circuit, there's also a prominent tax court case out there, said no, that stock is not really in the corporate value because it's going to be immediately utilized to redeem a deceased shareholder's stock, and so therefore we don't count that. So it doesn't add to any potential estate tax. It doesn't add to the value of the corporation. Here we've got the Eighth Circuit going the other direction, and they're saying, yes, it is included in the stock base, and so this was about $3.5 million of additional value that was in the corporation, resulting in over $1 million of additional federal estate tax that had to be paid when the deceased shareholder died because they said that added to corporate value, it enhanced his stock value that was included in his estate. So now we've got a split of authority between the courts. But the problem we had in this case was that the brothers that owned this small business, privately, closely held business, did not follow the buy-sell agreement during life. They didn't do annual corporate valuations. They didn't do other things that the buy-sell agreement required. And so the court found it pretty easy to say, well, you ignored it during life. We're going to ignore it as a valid value-restricting agreement at death. And the result was they had to pay more than $1 million in additional federal estate tax.
I think that really hits home a point that you've talked a lot about is the importance of knowing what everything's going to do when it comes to the estate planning.
Right. Drafting of these agreements, absolutely critical, and then following what the agreement requires you to do during life is also absolutely critical. Those 2 points are important for farmers and ranchers to understand and remember when they have these type of documents to aid them in transition of their business.
That was K-State and Washburn law professor Roger McEowen, and his blog article will be linked in today's show notes, which you can find on agtoday.net.